Good morning, everyone. We'll start the session in 5 minutes. Team 5 to 6, do you have a researcher as well, or only two members are there in your team?
So we do have a researcher, but she's facing some connection issues. She would be joining the session as soon as she finds
Sure,
better connection.
sure. So we'll start the session in 5 to 10 minutes. Whenever she joins, we'll start.
So we can start the session. We don't have to wait.
Okay, let
So
us
both the
wait.
speakers are here from our side.
Okay, have the judges joined? Judges, can you hear me?
हाँ जी, हम प्रदीप आर्य।
नमस्कार सर।
नमस्कार जी। ये एक टीम का कोड नंबर है 526।
जी सर।
और दूसरी का
561।
561।
जी सर। Let us wait for Manish Mohan ji to join. Sir ने join करा हुआ है, but he's not there before the camera, so let us wait for him as well.
He would be joining. तो दोनों टीम आ चुकी हैं?
Yes sir, yes sir.
तो दूसरी टीम में भी
speaker is yet to join in due to some connectivity issue.
Okay, so let us begin the session in 5 minutes. Let all the members of both the teams join, then we will start the session.
Thank you so much, sir.
हेलो, नमस्कार। आ जाओ, बजे 1 बजे तक आ जाओ। हाँ हाँ, ओके। तो कोई से आगे पीछे कर लेंगे, पहले जो सी आगे शुरू करेगी उसी को सुनना शुरू कर देंगे। 561
पहले प्रोसिक्यूशन आएगी ना, तो वो 5 to 6 है।
ठीक है,
फिर वो आएगा आपका डिफरेंस।
Namaskar sir. We'll start the session in 5 minutes. The team members are yet to join, so we'll start the session in 5 minutes.
हाँ जी, मनीष जी नमस्कार।
नमस्कार प्रदीप भाई।
नमस्कार जी, नमस्कार। चलो, अधिवक्ता परिषद की इस मूट कोर्ट के बहाने मिल ली। और सब बढ़िया? दशहरा कैसा रहा?
बस दशहरा अच्छा रहा।
कोविड के कारण सावधानियां तो बरत ही रहे हैं बहुत ज्यादा।
हमने अपने अंदर के रावण को मारा योगा करके।
अच्छा, गुड 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 गुड।
वर्क फ्रॉम होम का थोड़ा उपयोग हो रहा है पिछले कुछ महीनों से, रेगुलर और बहुत रिलीजियसली योगा करके। आज पहली बार छुट्टी लिया क्योंकि 8 से 9 योगा होता है, तो लगा कि फिर वो नहीं कर पाएंगे।
Our second speaker is also joining, sir.
ब्लैक कोट डालूं क्या?
नहीं, ऐसा कुछ नहीं है। मुझे तो आया तो कमरे में एसी चला रखा था मेरे स्टाफ ने, तो मुझे थोड़ी ठंड सी लगी तो मैंने तो पहनी ली। तो एसी की वैसे जरूरत नहीं होती बहुत बार आजकल, ये 2-3 दिन से 4 दिन से मौसम में बदलाव है।
शुक्र है अभी पराली का सिलसिला शुरू नहीं हुआ है।
मैं पंचकुला गया था, रास्ते में 2-3 खेतों में बड़े लेवल की पराली जल रही, तो जलेगी क्या? तो एक स्पीकर को लगभग 15-15 मिनट देने हैं।
Team 5 to 6, have all the members of your team joined?
Yes, sir. Sir, is there a compulsion that the researcher has to join because she is
Not
facing very?
compulsory. It's not
Okay, sir.
compulsory,
So
but
both
I
the speakers
request
are
all the participants to turn on their cameras.
Sure, sir.
Welcome all.
Namaskar everyone, let us begin this session. So we have two prestigious members of the bar with us today who will be acting as the judges. We have with us Mr. Pradeep Kumar Aryaji. Sir has been practicing since 1992. Sir practices before the Supreme Court as well as the High Courts. Sir has also represented many clients in many high-profile matters. As a defense counsel, Sir has represented the accused in Deepak Bhardwaj murder case. Sir has also represented Harpreet Kaur in Baba Ram Rahim's case. So we welcome you, sir.
Thank you.
We also have with us Shri Manish Mohanji. Sir has been practicing since 1996. Sir is mainly practicing before the Supreme Court as well as the High Courts. Sir is presently a standing counsel before the Delhi High Court. Sir has delivered many lectures before many departments. Sir has also deposed as an expert on Indian law in the High Court of Singapore in a dispute between the ITC group. Sir has also many publications in his name. So we welcome you, sir. I also welcome the participants from both the teams. So before we begin the session, I'll give a short. I'll just explain the short rules of the session. I hope that both the teams have received the complete rule book.
Yes, sir.
So I'll just read the rules shortly. So each team will have a maximum of 30 minutes to present their oral submissions, including time for rebuttal. Maximum of 5 minutes can be reserved for the rebuttal, which can only be reserved for any one speaker. Teams are requested to notify the division of time between the two speakers as well as time for rebuttal at the beginning. No speaker will be permitted to address the court for more than 20 minutes. Teams will be intimated on every 20 and 30 minutes. Judges at their discretion may extend argument time to a maximum of 10 minutes per team. Teams will strictly maintain anonymity during the complete session and also while referencing to any case laws using present now option. At the time when one participant is speaking, others are expected to keep their microphones on mute. So, which team is representing the state?
So team 561.
561. So, team 561, could you please tell me the time that each speaker would be taking?
12 minutes each, sir.
10 minutes each.
12, sir.
12. Okay. And
5
4 minutes.
rebuttal,
Sorry. 5 minutes for rebuttal. Okay.
which would be taken up by speaker 1, that is me, sir.
Okay. So, let us begin the session.
So, can I inform about our time division?
You may tell the time division after the submissions of the prosecution is completed. Then
Sure,
thereafter
sir.
you can. Thank you.
Thank you.
May I start, your lordships?
Yes.
Much obliged. May it please the court, the counsel is appearing on the behalf of the prosecution in the case of State versus Sameer and others. The counsel seeks permission of your lordship to state the statement of jurisdiction.
Yes, please.
Much obliged. The court has jurisdiction in the particular instance under Section 22 of the NIA Act 2008. The council seeks permission of your lordship to present the statement of facts.
Yes, please.
Much obliged. Based on secret information which was given by the informant, officers of the Special Cell of Delhi Police raided a general coach of Farakka Express on its arrival on Old Delhi railway station on 25th February 2015 at 10:55 hours, during which two accuseds were detained at 11:20 hours, namely A1 and A2, which in the present case are Sameer and Monu, in the possession of bags, each holding high quality fake Indian currency notes of 2000 rupees denomination and a face value of 5 lakh rupees each. Upon further investigation carried on by the Special Police Cell and the National Investigation Agency, they uncovered that the accused were working in consonance with the terrorist group Lashkar-e-Taiba. They were coming in from Malda and had procured the FICN from accused number 3, who is Kalu Mama, which was to be given to PETA to carry out a bomb blast on the military convoy in Pulwama with their co-conspirators PETA, as has been mentioned before, accused number 4, who committed suicide to skirt an interrogation, and Sohail, accused 5, who is still absconding. Accused 1, 2, and 3 were thereby charged under the relevant sections of the Penal Code and the Unlawful Activities Prevention Act 1967. The Council would now seek the Court's permission to present the statement of issues.
Yes.
Much obliged.
Carry on and don't waste your time in waiting for our permission.
All right.
Please carry on.
Thank you, Lordship. The first issue up for contention before your Lordship is whether the actions and intentions of the accused in this matter successfully warrant the penal charges that have been framed against them. And secondly, whether the accused were engaged in a terrorist activity, thereby bringing them under the ambit of the Unlawful Activities Prevention Act 1967. It is submitted before your Honor that the Council would be taking up issue 1 and my co-counsel would be taking issue 2. The Council would now proceed to the arguments advanced. The accused had conspired to wreck the sovereignty of India and topple the monetary stability by plotting baleful schemes to bomb the army convoy that would strike fear within the minds of the populace. In furtherance of the same honorable court, they had not only gone on to print, but to effectively possess and transport fake currency and have brainwashed the youth of the nation. The arguments presented before the honorable court is twofold. Firstly, in the case of Attorney General of India versus Amrit Lal Prajeevan Das, the Apex Court defined the term security of the state used in entry 3, list 3 very broadly. The security of the state, honorable court, is affected by the weak and vulnerable economy in the modern state. And the security of the state is not so much as ensured by its physical might, but by its economic strength. Both of the things that ensure the sovereignty of the Union of India were put in serious jeopardy by the intents and the resultant acts of the accused in the present case. They have been elucidated by the virtue of the CFSL report, the CERT and expert opinion, the admissions under Section 17 and 30 of the Evidence Act, and the presence of money as a precursor to a bomb blast scheduled on 15th August that would stifle the piety of the territorial and monetary autonomy of the country. Secondly, Honorable Court, as has been laid out in the case of State of Maharashtra and others versus Somnath Thapa and others, to establish a charge of conspiracy, knowledge about the indulgence in either an illegal act or a legal act by illegal means was necessary. The accused in the present matter were together engaged in the criminal act of transportation of high quality fake currency to fund the bomb blast on Indian Army convoy on Independence Day, Honorable Court, with accused 3 being one of the masterminds of the plan and accused 1 and 2, namely Sameer and Monu, implementing the same very nicely, thus fulfilling the criteria of engagement in the illegal act and the effective acts in pursuant to the same. The above has been proved via the investigation of the National Investigation Agency and the accused's confessions. The analysis of the CDRs and the phone data of the phones seized from the accused, accused 1 Sameer and accused 2 Monu, clearly establishes their movement from Madhya Pradesh to West Bengal and their frequent telephonic conversations between Sameer, Kalu Mama, Sohail, Peter, and Monu. The accused's mens rea is shown by the following. Firstly, Honorable Court, the apprehension of the accused, which substantiates the informant Guddu's information, which was received on 24th February 2015 by the Special Police Cell, Rodhi Road. Secondly, the admissions which have been given by accused 1, 2, and 3 in pursuance of Section 30 which coterminously bring about a singular set of circumstances, thereby complementing the findings of the National Investigation Agency and the Special Cell. Thirdly, the existence of high quality fake Indian currency notes of face value of rupees 10 lakh and 2000 rupees denomination. Honorable Court would appreciate that this is despite a currency crunch in the country due to demonetization with the advent of 2015, which was sinisterly hidden in the secret cavities so as to conceal their real intention and existence of currency. Fourthly, Honorable Court, the presence of accused 1 and 2 in Malda, despite having jobs in New Haryana, which is, as has been mentioned by my learned friend, 1,400 kilometers away from Malda. Fifthly, the Dulhan Ki Vidai Ka Waqt, a code which has been repeated by the accused and the defense witness, substantiates the above. Sixthly, accused 3, Kalu Mama's blatant efforts to not only mask his illegal activities, but to effectively misguide and derail the investigation by haphazardly removing evidence from his house and concealing the whereabouts of the manufacturing of fake currency, and Sohail, that is accused 5, thereby trying to devoid the investigation of incriminating evidence from houses of accused 3 and 5. Lastly, Honorable Court, following the opinion of the court in the case of Ash Mohammed versus Shivraj Sharma, it is a well accepted principle that the concept of liberty is not in the realm of absolutism, but is in fact a restricted one. The cry for the collective of for justice, its desire for peace and harmony, and its necessity for security cannot be allowed to be trivialized, which the council submits will be trivialized if the perpetrators who are threatening the very being that the nation, that Union of India is, are not put behind bars and brought to justice. The council would yield her time to her co-counsel, who will be dealing with issue 2.
Can you tell me one thing? You have telephonic records ki both the accused were talking to each other. Is there any conversation proof with the prosecution?
Yes,
Conversation.
Yes, Honorable Court. Kalu Mama, in his admission, has also mentioned that the telephonic conversation which happened on 1st of February regarding a deal which was to be materialized regarding the exchange of
My question is, what exactly transpired between the two callers? Is that conversation is in the prosecution file or not?
No, Honorable Court.
In
The
a-
exact conversation is not
Yes,
been
now the
provided,
issue-
but the insinuation of the same has been done by the Kalu Mama.
Now the issue, but you tell me one thing. In absence of the exact conversation, mere telephonic calls, what could any exact inference could be drawn about the guilt of the or mensira of the two persons talking, apart from all other evidence which is on record?
Much obliged, Honorable Court. The council submits that in the present case, it's not just the telephonic conversations, but the location of the towers also mentioned. As the council already submitted that these people, the accused 1 and 2, are residents of New in Haryana. It is a very far, it's a considerable distance between the two states of Haryana and West Bengal, and also Madhya Pradesh. But they've been traveling in consonance.
My question is very short. You answer it one line. You don't have the conversation details.
Yes.
Is it right? In absence of conversations detail, how can prosecution how much rely upon mere proof of talking to each other in absence of the substance?
This has been corroborated, Honorable Court, by different instances.
But
And also on 23rd February, when they boarded the train, Farakka Express, there was an increase in conversation which happened, increase in call, as been shown by the call records also, which corroborate the same.
Can I rephrase this question of my brother in a different manner?
Sure.
For example, we are having a very frequent conversation regularly for the last few days. If I indulge in any criminal act, will that also make my brother liable? Just because we have been having a frequent conversation?
Much obliged, Honorable Court. It's not that the call records have been taken in isolation. The evidence is not the only thing which the prosecution has been relying upon. It has been further corroborated by the various evidence which have been put on record. The existence of the fake currency which was there, for example. In the midst of demonetization, how would they have all 2,000 rupee denomination notes when a demonetization has been going on and there is a currency crunch? Also, they've been frequently talking to each other. That means they have been in constant contact. That this has been further to corroborate that they have been in a constant contact with each other. And this is not just a telephonic conversation. They've in person traveled to different places in Malda and Madhya Pradesh as well, in pursuance to the same. And the court would also note that they boarded the train from Malda itself despite hailing from noon. Also, the code name which talks about Dulhan ko sajana padega, that has also been repeated. So they came up with a code name to as a precursor to the blast as well. So all of these corroborate the the call records as well.
Okay, go ahead.
Much obliged.
The council seeks permission of your lordship to proceed with the second issue, which is whether the actions and the intentions of the accused in this matter successfully warrant an ongoing trial for which they were charged under UAPA. Much
Ricky,
obliged, Honorable Court. Your Lordships, the purpose of terrorism lies not just in the violent act itself, it is in producing terror. It sets out to inflame, to divide, and to produce consequences which are then used to further justify terror. The Honorable Delhi High Court has said in the Northeast Delhi Rights case that the intent and the purpose of Parliament in enacting UAPA and in amending 2004 and subsequently in 2008 is to bring terrorist activities within its scope. The intent and the purpose was and could only have been to deal with matters of profound impact on the defense of India, your lordships. In the instant case, the question of law is that the fiction concocted by my learned friend, as has been insinuated via his written submissions for the accused, though are attractive at first blush, however, they deserve to be dismissed as the very agreement, concert, or league is the ingredient of the offense. It is not necessary that all the conspirators must know each and every detail of the conspiracy as long as they are co-participators in the main object of the conspiracy. This, your lordship, was affirmed by Honorable Supreme Court in the case of Yashpal Mittal versus State of Punjab. The instantaneous charge of terrorist act is under section 15, subsection 1, clause A, subclause 3A, is subject to rule 5, that lays down considerations that may constitute damage to the monetary stability of India. This rule read conjointly with Rule 6 that lays down procedure that has to be considered to apply section 15 and 16 of UAPA. These two rules of the investigation of high quality counterfeit Indian currency offences rule of 2013. Your lordships, to this purpose, submissions shall be twofold in line with the essence of terrorism, namely, satisfied conditionality 5 and 6, furthering the authenticity of the terror charges so levied, concomitantly with the doctrine of confirmation by subsequent events. The Council hereby professes that Rule 5 edicts observance of the prescribed considerations, since circulated or traffic denominations must match those in circulation by RBI at that point of time, which currently are fulfilled as the accused were caught in possession of 250 notes of high quality fake Indian currencies were possessed from them, which were of denomination 2000, having total face value equivalent to 5 lakhs each. It is submitted that to attest indemnity under this head, the law further mandates an investigating officer to forthwith send the seized currency thereof to the notified authority for their forensic examination, which in the instant case with the seizure of the high quality fake Indian currencies, the special cell Delhi police concomitantly solicited CFSL's and CBI's report on this aspect. On that account, your lordship, your attention is also requested to 17.09 paragraph of Exhibit 2, whereof the met condition is substantiated. Your lordships, a person acts purposely if his conscious object is to bring a particular result, and acts knowingly if he is aware that it is practically certain that his conduct will lead to that result, which in the instant case is done by the accused conforming to the terrorist act, which falls under the ambit of section 15 of UAPA. That being said, the council further invites attention of honorable court at various paragraphs, namely 17.10, 17.14, 17.15, read with 17.25 of Exhibit 2, and submits that Considering that this is not a simple case of unworried possession of few fake currency notes, the act done by one or statements made by one is admissible against the co-conspirator, which is in line with the opinion of the Honorable Supreme Court in the case of Swarup Lal and others versus State of Maharashtra. Confessions, which is a term used in criminal law, is a species of admission that has been defined under Section 17, Your Lordships. Confessions are considered highly reliable because no rational person would make admission against his interest unless he is prompted by his own guilt self to tell the truth. This was said by the judge in the case of 1996 Lajpat Nagar bomb blast case, whereof an accused named Javed Ahmed Khan confessed, and his confession led to the cracking of the case. Consequently, the apex court in the case of Shankariya versus State of Rajasthan, while calling confession a catalogue of events, certified that it is a presumptive evidence of its truth, and the court should carefully examine the confession and compare it with the rest of the evidences in the light of the surrounding circumstances and the probabilities of the case, which in the matter, Your Lordship, is the case as can be corroborated by multiple testimonies of the accused as well. More specifically, accused 1, 2, and 3, namely Sameer, Monu, and Kalu Mama, were inter alia one of the most involved in the terrorist act, and their involvement in organizing the terrorist act or the illegal activity invigorated the fundamentalist and the anti-Indian element groups to flourish, to nourish. Interestingly, Your Lordship, while dismissing a bail application, the Honorable Delhi High Court, in the case of Vikas Kumar Sharma versus State, reiterated that possession of large numbers of fake currency notes cannot be regarded as a dormant possession, but it would amount to active transportation of such notes. Your Lordship's attention is also invited to the tower locations of the accused mobiles that were procured from their call records and the transcripts that were made on important dates. Then, an expert opinion of CRT was procured under Section 45A of the Indian Evidence Act with respect to the electronic evidence by NIA. This was done as a matter of right to investigate the scheduled offences provided under Section 6 of the NIA Act. Thus, it is clear as daylight that the tower locations and the call details of the mobile instruments conclusively corroborate Sameer and others' culpability. To mark the presence of knowledge and intent, in pursuant of the common design, the accused is also proclaimed to have prior meetings in a locality called Malda, where it is alleged that the conspirators pledged to plan for executing a bomb blast on convoy of Indian Army in Pulwama, that too on the auspicious occasion of 69th Independence Day of India. Their pledge to plan for executing a bomb blast was shamelessly performed against a country that provides them home, furthering their malified intent and presence of mens rea as an attempt was made by the defense to look innocent via the claims of mere exercise of their constitutionally guaranteed right to protest. That being said, the conditionalities of Rule 6.4 stands confirmed. On that account, court's attention is also requested to 17.30 paragraph of Exhibit 2, whereof the met condition is substantiated. This 17.10, read with 17.30 paragraph of charge sheet, certifies attained conditions that have been mentioned under clause A, B, F, J of Rule 464 of the Investigation of High Quality Counterfeit Indian Currency Offences Rule 2013, Your Lordships. Furthermore, during the course of investigation, it was also certain that Sameer and others were receiving money from the terrorist and terrorist organizations that were operating out in Pakistan and Bangladesh. With respect to this, admission was made by accused 3, as has been magnificently countered in 17.25 paragraph of charge sheet of Exhibit 2. Your Lordship, in closing, the Council would humbly submit that the greatest danger of terrorist bomb is in the explosion of stupidity it provokes, and this cannot be equated with the usual law and order problem within a state. Rather, it is a threat to the security of our nation and its citizens. It is a challenge to the whole nation and the invisible force of Indianness that binds this great nation together. by indulging in terrorist activities organized by groups or individuals who are trained, inspired, and supported by fundamentalist and anti-Indian elements. These groups are trying to destabilize the country. It deserves to be penalized not just as a criminal act, but because it surpasses mere criminality, Your Lordships. With this, the Council seeks permission of Honorable Court to proceed with the prayer.
Yes, please.
Much obliged, Honorable Court. Whereof, in the light of the facts of the case, issues raised, arguments advanced, and the authorities cited, the Council for the State most humbly pray and implore before the Honorable Court of Learned Special Judge (NIA) that it may be graciously pleased to adjudge and declare first, accused guilty of the penal charges under sections 120B, 121, 123, 201, 489B, and 489C, Your Lordships, coupled with UAP charges under section 16, 17, 18, and 20 on account of their involvement as a member of the terrorist organization in invigorating the local militant groups to nourish. Secondly, pass a sentence of conviction in consonance with their proved intent to execute a terror conspiracy aimed at destabilizing India's economic security. And in or pass any order as it may deem fit in interest of equity, justice, and good conscience. For this act of kindness, the state shall be duty bound forever.
You said that accused 3 made a admission about his involvement in the crime. Is it admission or confession or disclosure? What was it?
Your Lordship, a confession, which is generally used in criminal law, it is a species of admission that has been defined under Section 17. They admitted their respective roles, and in this regard, the Council would also like to point out the fact that a prior statement in one's own interest may not be a verifiable evidence, but a prior statement, it was to one's interest, would be considered a verifiable evidence. This has been brought in highlight by Honorable Court's opinion in the case of Sathura Charal Vijayarama versus uh, versus Nimaka Jayaraju, Your Lordships.
Good. You are praying today itself in the first hearing, the person should be convicted and sentenced accordingly. But there should be some gap between conviction and sentence. After conviction, counsel and the party should be given some time to argue on sentence, because sentencing policy is also very important. Suppose in a Dory death case, minimum sentence is 7 years, but maximum can go up to the life. So in a particular case, when it should be 7 would be sufficient, and or in what case it would be 8 sufficient, 9, 10, or maybe life maybe sufficient. There should be some adequate time. So why you made 2 prayers together in one go? Conviction without waiting for the order whether you would succeed in your case or not.
Your Lordship, this contention has been made by the council appearing for the state in lieu of the act that has been committed by these accused. They have not. The act that they are committing is not a simple case. It is a threat to the security of a nation, and it is a big thing. It is not a simple simple case of unworried possession of few fake currencies. It just not threatens India's sovereignty and economic security, but it also hampers in a way India's image at an international level. So that is the reasoning behind council's contention that a sentence shall be passed for their
conviction अलग होती है, conviction के बाद sentence के लिए time दिया जाता है.
See, I have twofold questions for you. First is the basic issue. Can there be an FIR under 201 of IPC? And secondly, how do you make out a case? How do you point out the ingredients of 201 IPC? in the facts of the present case?
Your
How can
Lordship,
you show the ingredients of 201 IPC?
Your Lordship, can the question be repeated once? The council is facing some technical issues.
First issue is about 201 IPC. Can there be an FIR under 201 IPC? Because it is not. And secondly, how do you make out an ingredients in the facts of the present case under 201 IPC?
Your Lordship, in lieu of the question posed, the council would submit that the facts from the instant case that uh, highlight the presence of this particular section or this particular charge against the accused is the fact that the currencies that were possessed from there were hidden in the secret cavities of the respective bags. This also furthers intent. This, when used corroborately with other facts like the accused Kalu Mama, he not just in a way tried to evade from the from the questions that were posed to him by NIA, but also he destroyed many of the evidences from Sohail's house. So these are the facts based on which the council is contending that there has been an attempt made by the accused to destroy the evidences and mislead or derail the investigation.
Are there specific instances of destroying the evidence? Are there
Your
specific instances of destruction of evidence?
Yes, Your Lordship. Kalu Mama has destroyed evidences. More than that, Sohail has also absconded, and Peter's attempt to suicide, and it being successful, also points out towards the malified intent or presence of mens rea. And there has been many efforts to either destroy the evidences or conceal important information that has to be revealed to the during the course of investigation.
Okay.
Good. Can I ask one more question from you? You used word admission of qua accused number 3. जो आपके पास मटेरियल है उसमें कहीं एडमिशन शब्द का इस्तेमाल हुआ है? It was a criminal case. Criminal case में admission शब्द का word has been used by you that a particular accused admitted his guilt before the investigating agency. Admit word in common practice is, and under the law also, is corner to that criminal trials, criminal investigations. Here are the words either disclosures or confession. Either a accused can disclose his involvement in the crime or about the information which he has about the crime, or he can confess his involvement. And confession is also admitted to a particular extent, to the extent where it leads to some recovery. Otherwise, any confession made to the police authorities under the general law is not admissible. So, from where you got this word admitted?
Your Lordship, this has been mentioned in the charge sheet itself that the accused has admitted their guilt, admitted their respective roles in the act.
Okay, good. Second team, defense.
Request the second team to tell us the time of the taking the speaker.
So, I, being the first speaker, would take 14 minutes of the court's time, and the second speaker would also take 14 minutes, and 2 minutes are reserved for the rebuttal.
Sure.
Shall I proceed?
Yes, please. Don't wait for permission. You can go ahead without wasting time on that.
May it please the court, this is the counsel number 1 representing the side of defense in the case of State versus Sameer and others. The counsel seeks permission to collectively address the bench as Your Honor.
Yes,
Yes.
please.
Okay, with the prior permission of the court, much obliged, Your Honor. With the prior permission of the court, the counsel would like to present the major contentions of the defense in this case, which are as follows. Firstly, there exists no conspiracy between the accused to execute the bomb blast. Secondly, the accused did not disappear any evidence or falsified facts to screen the other accused. Thirdly, the accused are innocent people who were not in possession of any fake Indian currency notes. Fourthly, the connection of the accused with local militant groups and terrorist groups has not been substantiated with proof by the prosecution. And lastly, Your Honor, the accused had no intention to wage war against the state of India, and the same has not been proved by the help of any evidence or by beyond reasonable doubt by the prosecution. These were the major contentions of the defense, Your Honor, in this case. Further, with the prior permission of the court, the counsel would proceed with the oral argumentation. Your Honor, declaring someone as a terrorist is, in other words, declaring someone as dead. It is the civil death of a person. It ends all the opportunities and possibilities for someone who has been wrongfully accused of committing such an act. Even if the accused are not convicted, Your Honor, it leaves an indelible mark on that person's existence. Your Honor, the prosecution has a duty to prove the conviction of accused beyond all reasonable doubt. Although, Your Honor, the defense believes that the prosecution has lacked somewhere in that part, and hence the defense is here to address those irregularities. Your Honor, the first counsel would be dealing with the first issue pertaining to the liability of accused under sections 120B and 201 of 120B, 121, 123, and 201 of IPC. And my learned co-counsel would be dealing with the liability of accused under sections 489B, 489C of IPC, and sections 16, 17, 18, and 20 of the UAPA. Your Honor, to begin with, it could be said that to establish the liability for the offense of criminal conspiracy, certain essentials must be taken into consideration as per its definition, which is laid down under section 120A of IPC. Firstly, Your Honor, there must be an agreement between the conspirators and meeting of mind for committing such an illegal act. Your Honor, this agreement could be proved through circumstantial evidences by establishing the links between the conspirators. But it is humbly submitted, Your Honor, that the prosecution has failed to prove the link between the parties that led to this conspiracy, as there exists no authentication for the evidence submitted. Your Honor, there are many aspects that raise doubts about the connection between the accused. Firstly, Your Honor, it is imperative to mention that the accused Samir and Monu used to live in Noor district of Haryana. And the accused Kalu Mama used to live in Kaliachak Malda of West Bengal. Your Honor, the distance between both the places is greater than 1400 kilometers. Your Honor, and NIA could not locate any common place where the alleged conspirators used to meet. Hence, Your Honor, the only medium left for the communication between the accused is through telephonic conversations. Your Honor, however, it is mandatory to produce a requisite electronic certificate as per the provisions under Section 65B, subsection 4 of the Indian Evidence Act 1872, to authenticate the call detailed record submitted by the prosecution. Your Honor, in the latest case of Arjun Panditrao Khotkar versus Kailash Kushanrao Gorantyal, the bench may peruse to para number 6 to 11 of the memorial of the by the side of accused. The Honorable Supreme Court had opined that it is mandatory to produce the electronic certificate in cases where producing the original database or computer system becomes impossible. Your Honor, in the case, the call detail records retreated from the internet service providers, namely Jio, Vodafone, and Airtel, would be deemed as secondary, as they were analyzed to submit only particular details and call records between the accused. Your Honor, but the prosecution must have produced the requisite certificate. Your Honor, the absence of the same raises serious doubts on the believability of the call records. Secondly, Your Honor, the prosecution has said that the accused Kalu Mama was taking direct instructions from the accused Sohail. Your Honor, however, the prosecution witness Iqbal Khan in his Exhibit 6, in the Exhibit 6 in his prosecution witness statement of the fact sheet, has himself stated that Kalu Mama and Sohail were not having any cordial relationship. Your Honor, then how could there be a meeting of mind between them? How could there be a common intention? Kindly peruse to the Exhibit 6 of the fact sheet. Thirdly, Your Honor, it has been it has been said in the case of State of Tamil Nadu versus Nalini, the bench may peruse to para number 14 of the memorial of the accused that mere association with one principal offender or even knowledge about the conspiracy cannot make a person a conspirator. It is the agreement between the parties, which is the sine qua non of the offense of conspiracy. That means agreement is an essential aspect that must be proved to establish the offense under conspiracy. Your Honor, indeed, the accused used to work together, but Your Honor, they were working for an initiative which ensured informed citizenry. They were working for the minority groups. Your Honor, just on that basis, it could not be deciphered that the accused were involved in a conspiracy to execute a bomb blast. Your Honor, further, it was also held in the case of Kirtipal versus State of West Bengal, the bench may peruse to para number 19 of the memorial. It has been clearly said that the telephonic calls and the recovery may raise suspicion against the accused, but mere suspicion itself cannot take place of the proof. Your Honor, the accused persons are part of an initiative that speaks against the policies of government. Hence, it is apparent that they must communicate through telephonic conversations regarding their initiative or regarding its development. Your Honor, that could be used to divert the court's mind to look into the facts differently. Your Honor, mere suspicion could not hold them accountable for this alleged conspiracy. Your Honor, at last, the counsel humbly submits that the evidence submitted by the prosecution is not wholly enough to validate the links between the accused. Moreover, there is no authentication as per the law laid down under 65B, subsection 4 of the Indian Evidence Act. Hence, Your Honor, the accused must be acquitted of charges under section 120B, read with sections 121, 123, 201, 489B, and 489C of IPC. Your Honor, further coming to the issue pertinent to sections 121 and 123 of IPC, Your Honor, it is most humbly submitted that the accused are not triable before this learned court under sections 121 and 123 of IPC, as the condition precedent laid down under section 196 of CRPC has not been fulfilled in the given case. Your Honor, it explicitly states the section 196 of CRPC that no court shall take cognizance of offences mentioned under Chapter 6 of IPC. Your Honor, that also includes Section 121 and 123 of IPC. Your Honor, the Law Commission in its 41st report has also stated that Sections 196 of CRPC exist to prevent unauthorized persons from intruding in the matters of state. Your Honor, you may peruse to para number 22 of the memorial of the accused. Additionally, Your Honor, it has been quoted at numerous occasions by the Supreme Court that that sanctions are condition precedent if cognizance is to be taken for any offence under Chapter 6 of CRPC. Your Honor, the defence has relied on the case of CBI versus M. Shivamani. You may peruse to citation number 17 of the memorial for the same. Your Honor, additionally, in both the letters of sanction under Exhibit 4 and Exhibit 5, there is no mention of the accused name Kalu, who is the accused number 3. The name of the accused has not been mentioned anywhere. Thus, Your Honor, it can be inferred that the state does not want to prosecute accused Kalu under the said sections. Furthermore, Your Honor, if we examine the letter of examine the letter of sanction under Exhibit 5 of the fact sheet, it does not include the offence of waging of war against the state. That is 121 and 123 of IPC. Your Honor, thus it can be inferred from this step of government that they do not want to prosecute the accused for the offences of waging war against the state and for concealing with intent to facilitate design to wage war. Your Honor, further coming to the issue of Section 201 of IPC, Your Honor, it is most humbly submitted that the accused are not liable under Section 201 of IPC for causing disappearance of potential evidence or for giving false information to screen the other conspirators. Firstly, Your Honor, it has not been extensively proved by the prosecution that the accused were involved in a conspiracy in the first place. Your Honor, the defense has tried to raise certain doubts in front of the court for disproving the conspiracy earlier issues. Secondly, Your Honor, the prosecution has not provided any evidence with respect to the liability of accused under Section 201 of IPC. There exists no proof with respect to destruction of evidence of the accused. And how could we only rely on the statements made by the police, Your Honor? Furthermore, in the case of Padmini Mahendrabhai Gadda versus State of Gujarat, the bench may peruse to citation number paragraph 30 of the memorial and citation number 21 of the memorial by the accused. The Supreme Court in the same case had clearly opined that while considering charge under Section 201 of IPC, it is mandatory for the prosecution to prove that the accused actively participated in the matter of disappearance of the evidence, which has not been proved with help of any substantial evidence by the side of prosecution, Your Honor. Your Honor, the police or NIA did not encounter any instant whatsoever where the accused have not cooperated with them or tried to hinder the investigation process in any way possible. Your Honor, hence the counsel humbly submit that the accused are not liable for causing disappearance of any potential evidence, Your Honor. Therefore, they must be acquitted for the same under Section 201 of IPC. Additionally, Your Honor, there are certain irregularities in the story of prosecution that the defense wishes to address. Firstly, Your Honor, it is important to note that according to the charge sheet under Exhibit 2 of the fact sheet, it has been clearly mentioned that Delhi police was informed about 2 suspects for the transmission of fake Indian currency notes for some criminal activity in the country by the informant named Guddu Singh, who used to own a pan shop near the old Delhi railway station. However, Your Honor, the special cell of police in the FIR under Exhibit 1 charged not only 2 accused but 5 accused, including Kalu, Peter, and Sohail, who are accused number 3, accused number 4, and accused number 5, respectively. And Your Honor, those accused were charged of all those offences which were Samir and Monu were charged of. How could the police even know the existence of 3 other accused when no interrogation has been taken place and no investigation has been done in the preliminary stage, and the names have been added in the FIR in the first place? Secondly, Your Honor, the description of the apprehended persons in the FIR and description of the persons in the charge sheet is very different, which raises serious doubts with respect to the apprehension of innocent people, Your Honor. Moreover, FIR is an important document that initiates the criminal machinery against any particular accused. And Your Honor, the wrong description of the accused in the document shatters the basis of it. It hampers the initiation of criminal machinery properly. Thirdly, Your Honor, it is contended that the prosecution does not have any direct evidence whatsoever to prove that Kalu is somehow involved in the commission of said offences. Your Honor, the prosecution wholly relied on the statements given by the accused in the custody of police. Your Honor, it is very humorous to me, and the counsel humbly believes that it is the point when the prosecution must know that it is a settled law. Your Honor, the Honorable Supreme Court has also stated in numerous cases that the statements recorded by the police under Section 161 of CRPC are not evidence for prosecution. It has no admissibility or entertainability in front of this court. Your Honor, the prosecution's case is relying on the statements made by the accused, but Section 161 cannot be used against the accused themselves. The statement under Section 161. Instead, the statement should have been recorded as per the Section 313 of CRPC. Lastly, Your Honor, if the accused are convicted just on the basis of incomplete evidence and so many irregularities in the investigation, it would vitiate the purpose of justice for them. Your Honor, there is a possibility that these are innocent people and the police apprehended the wrong persons in the first place. Your Honor, it would not be a conjecture to say that police deliberately framed the accused and ran a premeditated, prejudiced investigation since its inception. My co-counsel would be dealing with the possibility of the same, Your Honor. Furthermore, Your Honor, the counsel humbly requests that the court must adopt a cautious approach and should record the conviction of the accused only if all the links and the chain are completely pointing towards the guilt of the accused. Your Honor, the accused have been under judicial custody for the past 6 years. The trial is at the final argumentation stage, Your Honor. Just on that basis, that some mere speculation that they were part of a conspiracy to execute a bomb blast, they should not be convicted in the case, Your Honor. Declaring the accused as terrorists would be equivalent to putting a full stop at the end of their sensitization program. They would not be able to work in favor of the minorities and in favor of the people who had been victims of the governmental malpractices. Your Honor, this is the first. With this, the first counsel rests his case here. It has been an absolute pleasure and honor to argue in front of this court. Your Honor, further, my co-counsel would be dealing with the second and the third issue.
Only one question in short. You made a reference to Section 196 of CRPC. Which part of that provision you are relying upon?
So 196 subsection 1.
Of CRPC.
Indeed, Your Lordship.
Yes, please.
So may I read it?
Yes, please.
No court shall take cognizance of any offence punishable under Chapter 6 or under Section 153A, Section 295A, or subsection 1 of Section 1 of Section 505 of the Indian Penal Code 45 of 1860. Sir, Chapter 6 has been mentioned here, and the sections 121 and 123 includes these sections are included in the Chapter 6 of IPC. So the essentiality of taking cognizance is fulfilled after sanction have been provided by the state government, by the central government, or the district magistrate, which has not been provided under Exhibit 4 and Exhibit 5 of the fact sheet, Your Honor.
Team 561, be ready to respond to this.
Yes, Honorable Court.
I want to put a question to you.
Indeed, Your Honor.
You said that there is no place of meeting amongst these accused has been established by the prosecution.
Indeed, Your Honor.
Under the conspiracy law, meeting of place is important of the accused, or meeting of mind is important? What is required under 126? moment.
Indeed, Your Honor, meeting of mind is much prioritized. But, Your Honor, in this case, the prosecution is wholly relying on the meeting of mind on the basis of call detailed records, which cannot be admissible in the court under Section 65B of the Indian Evidence Act, which requires the requisite electronic certificate, as laid down by the latest law of Arjun Pandit Rao. It cannot be admissible in the court because the requisite certificate is not proving the same.
161 CRPC, you said it cannot be read in evidence.
Indeed, Your Lordship.
So in this case, for what purpose that has been relied upon?
Your Lordship, if you look into the Exhibit 7 of the Exhibit 7 of the fact sheet, all the statements of the defense witnesses, name it accused Kalu, Samir, or Monu, all the statements have been recorded under Section 161 of CRPC, which is not entertainable at all. How could we rely on the statement made under 161 as we have provisions as of Section 162 of CRPC, which says that the statements of the accused cannot be entertainable in front of this court, as made by if made in the custody of the police, Your Honor.
What is the use of statement under Section 161 CRPC?
Sir, it is just for the purpose of examination of the witness. It cannot be used in front of a court. It cannot be termed as a judicial confession.
I said, for what purpose 161 CRPC statement can be used?
Sir, 161 is, sir, it can be used for the purpose of investigation, but it cannot lead as a proper admission or proper witness for the prosecution in front of the court of law. It can be used for the purpose of investigation, Your Honor.
Contradict or confront करने के लिए इस्तेमाल हो सकती है तो same witness को. When a witness has given a statement under Section 161 CRPC before the police during investigation, and the said person who has given 161 statement appears before the court for his examination as a witness, तो उसकी 161 की statement का किस तरह से इस्तेमाल हो सकता है? Have you seen in this matter?
But sir, there also exists Section 25 of the Indian Evidence Act, which clearly says that confession to police officer not to be proved. Okay, sir. There also exists a provision.
Not confession always. 161 is any person acquainted with the facts and circumstances of the case can be called upon to explain and to assist the police about the crime. 161 is not always confession. It is not disclosure भी नहीं है ये, ऐसा नहीं है. So,
but so the prosecution is relying on the statement.
For what purpose in this matter has been used 161?
The prosecution has contended that it was admitted by the accused, and how could we address this as an admission?
Okay.
Because they clearly said that it has been admitted.
Okay.
If Your Honor has no other question, the other counsel would like to proceed. Much obliged, Your Honor. It was an honor to argue in front of the bench.
Thank you.
May it pleases the court, Your Lordship, in continuation of where my co-counsel left, I would like to carry on that as my co-counsel has already stated earlier, that since this investigation is premeditated, prejudiced toward the accused, I would like to carry on with respect to issue 2, that is whether the accused are liable under Section 489B, 489C of IPC. Your Lordship, to attract conviction under Section 489B and C, 3 ingredients must be fulfilled. The first is that selling, buying, receiving of fake Indian currency note. The second is that the accused must form the possession of fake Indian currency. And the third is that the accused must have knowledge or an intention to use the fake Indian currency as genuine currency. Your Lordship, in the present case, none of the ingredient has been fulfilled. I will come to the first point, that is selling, buying, receiving of the fake Indian currency at a later part when I will deal with the accused number 3, that is Kalu Mama. However, in the present case, the possession of the fake currency creates suspicion as to what is the investigation that is done by police. Your Lordship, if we see that police receive information that 2 people are carrying fake Indian currency on 24th, and on 25th at 10:15 hours, it is 11 a.m. in the morning, police reached railway station, and after that they have completed their procedure at 11:20 p.m. in the evening. For the same, Your Lordship, please peruse to 17.8 of the charge sheet, which stated that after the seizure from crime scene, on return to police special cell, case-wide FIR number 15/2015 was registered at police station, New Delhi. Your Lordship, as the as the timing here is at 11:20 p.m. in the evening, Your Lordship. This create a doubt of a 12 hour. What is police doing in between those 12 hour? This creates suspicion that they may have implanted the fake hidden currency in the possession of the accused. Further, Your Lordship, as has been stated in the section 100 of CRPC, the procedure to seizure, it is stated that independent witness must be involved so that to authenticate the procedure of seizure. In the present case, Your Lordship, the seizure takes place at a crowded place of railway station, that is an Old Delhi railway station. Your Lordship, in the present case, only one independent witness has signed the seizure memo, and one head constable signed the seizure memo. How can it be possible that at such a crowded place, at such a public place, police didn't find any of the public witness? They only find only one public witness which can authenticate the procedure of seizure. Thirdly, Your Lordship, in the seizure memo, in the seizure memo of both Samir and Monu, they have written the FIR number, that is 15/2015. However, it is clear from the charge sheet that they have filed FIR once they have done all the seizure and they have reached the police station. Before that, they do not have filed FIR. So how come do they know that the FIR number will be 15/2015? This require miraculous superstition, Your Lordship, because if this is the case, then I don't know whether it is admissible or not, but this creates suspicion that a reasonable man cannot know the FIR number without registering the FIR. Further, Your Lordship, as has been stated in the charge sheet, that when the police reached the railway station, they didn't know anything about any of the accused. They didn't know any detail, any description of the accused. They searched the general coach of Farakka Express, and during the whole time, the accused were present there. They cooperated with and if they would have tried to, if accused do have any ill will or any intention or any malice will, then they could have run from there very easily without getting apprehended. But they remained there. They cooperated because they know they do not have anything to hide. That's why they remain there. They didn't do anything. Further, Your Lordship, I would like to present my skin for the better understanding of the investigation rules, with your permission. Much obliged, Your Lordship.
Carry on.
Indeed, Your Lordship. Your Lordship, is it visible?
Yes.
Yes, Your Lordship. According to the investigation of high quality counterfeit Indian currency offence rule 2013, according to Rule 6, it stated that when a case has been registered upon seizure of currency suspected of high quality counterfeit Indian currency, the investigation officer shall forthwith send the currency or sample thereof to the authorized or notified forensic authority to the same. And Your Lordship, it has been stated that with the quickest possible mean, including email or anything, not later than 48 hours of the seizure. Your Lordship, sub rule 2, line 2nd, fourth last word. However, in the present case, Your Lordship, they didn't mention at what time they sent the fake hidden currency for the lab report. Further, Your Lordship, in the seizure in the rule in the rule 6 of sub rule 1, they stated that the preliminary report from the CFSL must be received to the officer in charge within 15 days of receipt of such sample. However, Your Lordship, in the case after 16, the preliminary report has reached to the officer in charge on 16th April. Please peruse to paragraph number 16.4 of the charge sheet. It stated that preliminary report of CFSL dated 16th April 2015. The police apprehended the accused on 25th February. They sent the fake hidden currency to the CFSL report, and they didn't mention at what time they sent, but they received CFSL report on 16th April, which clearly violates the rule established in the year 2013. Further, Your Lordship, as my co-counsel has mentioned that the investigation is premeditated prejudice toward the accused by mentioning the name and the section which is imposed onto them by the police. Further, Your Lordship, they stated that they found the fake hidden currency in the secret cavity of both the accused A1 and A2. In the statement given by Akash Singh, prosecution witness third, in his statement, he said that they, sorry, Your Lordship. Your Lordship, Akash Singh stated that after recovering the money from accused A1 and A2, they recovered money from black bag of Samir, that is A1, and in the maroon bag of Samir, A2. Beside the above mentioned quantity of FICN, some mobile set and some recovery was also happened. However, they didn't mention that they recovered the money from secret cavity, but they mentioned the same thing in chart sheet. This led to the contradiction that the investigation that has been done by them is different, and whatever they have written in the charge sheet is very different. Your Lordship, all the prosecution witness one, that is Akash Singh, the Rupinder Pal Singh, the superintendent of police, NIA IO, prosecution witness 4, stated the same thing. They didn't mention secret cavity when the statement was taken to them. Your Lordship, further, they've stated that Guddu accompanied them during the whole seizure. We can see to it, prosecution witness third statement, Akash Singh, last sixth line, that I duly collected all the evidence from the crime scene. After complying with the formalities, I asked Mr. Guddu to accompany me to the police station for the recording of their statement under 161. And Your Lordship, what Guddu Singh said that he simply provided information. He didn't say that he was present during the seizure at the time during the seizure at the police at the railway station. This creates doubt, Your Lordship, that what recovery they have done, whether they have done lawfully or illegally, or whether they have implanted the fake Indian currency or not. This creates huge doubt with the investigation of police. Further, Your Lordship, if you see the seizure memo of seizure of Samir and Monu, they stated that they have also found some cash. Please peruse to page number 29, Annexure B of accused Samir. They stated that they have recovered point 7 document and article in possession. Fifth point, they recovered some cash and a general railway ticket. However, Your Lordship, they didn't mention what is this sum cash, how much amount of this sum cash. They didn't mention that whether this sum cash is real or fake. They simply stated that this is sum cash. They didn't send this sum cash for the lab report to testing the veracity of it, that whether it's real or not. Or as I stated earlier, by simply miraculously superstition, they come to know that since this is a fake currency, this is real currency, we must left there and take this currency, we will send it to FCFSL. Your Lordship, how can police do that? Further, Your Lordship, as it is as also the investigation, the lab report which is provided by CFSL has also stated that as has been stated in UAPA and Rule 2013 also, that CFSL must record their reason as to why they're reaching on any conclusion. However, Your Lordship, you may peruse to paragraph number 17.35 of the charge sheet, that CFSL didn't record any of the reason as to why they concluded this is a fake Indian currency note. As it is provided in Schedule 2 of UAPA, it is very clear from that you must have to record reason, and based on that you have to reach the conclusion. CFSL didn't do that also, Your Lordship. Further, Your Lordship, I will come on the accused Kalu, whether Kalu is liable under section 489B and C of the IPC. Your Lordship, as stated by my learned prosecutors, that Kalu is the main conspirator of this conspiracy, and the police know about Kalu since they have made the arrest of Samir and Monu, that is on 25th February. However, they apprehended accused on 23rd June, and in between those time, nothing has been mentioned about Kalu. What Kalu have done, what they have done towards Kalu. They have gone for Peter and they have gone to Peter at Agar on 27th and 28th February, but they didn't bother to apprehend Kalu, which is a main conspirator, and they have stated that they have received money from Kalu. For that lead to my point that they have received money from Kalu. Your Lordship, it has been only stated by the apprehended accused that they have received money from Kalu. However, they didn't produce any evidence, any witness, anything which can say that Kalu has procured the fake Indian currency and they have handed it over to the accused. They said that Kalu buy the currency of fake currency of rupees 10 lakh by giving 3.5 lakh to the accused Sohail. However, when the police sees the Kalu house, when police search the Kalu house, they see some financial statement of both accused Kalu and his wife, Mr. Bibi. However, they didn't bother to see the financial statement to state it whether Kalu spent rupees 3.5 lakh, Your Lordship. And has been, and it is also said that the Kalu also stated that they have sorry, Charter also stated that Kalu helped Sohail to infiltrate to Bangladesh, and they stated that Shaurukh Khan helped him. They didn't take the statement of Shaurukh Khan. They didn't. And further, when asked by BSF person who was on the border, they stated that they have no news of infiltration of anything. So how can we rely on the investigation of the police or NIA, Your Lordship? Lordship, with this, I would like to carry on. I would like to further move to my issue third, that is whether the accused are liable under section 16, 17, 18, 20 of UAPA. Your Lordship, the first contention of the defense is that they do not require valid sanction against any of the accused, that is Samir, Monu, and Kalu. For the same, Your Lordship, we must have to understand the chronology of the event. That is, police apprehended the accused on 25th February, Samir and Monu. Government, through its letter, Exhibit 5, letter dated 30/4/2015, handed over the investigation to NIA. Your Lordship, on 11/5/2015, NIA kickstart with the investigation, and on 14/5/2015, they have the concerned authority has sanctioned to launch the prosecution against the accused, against both Samir and Monu. In the preliminary stages of investigation, how can they provide a sanction since they do not have any evidence, since they do not have any relevant fact? They never do any application of mind, and they provide the sanction on dated 14/5/2015. Please peruse to Exhibit 4, page number 45, Your Lordship. Lordship, to consolidate my point, I would like to quote some relevant paragraph from the case of State versus Mukesh Kumar Singh. It's a Delhi High Court judgment of 2018. Your Lordship, I'll be required 2 more minutes to wrap up my argument.
Carry on, carry on.
Much obliged, Your Lordship. Your Lordship, as stated, the validity of sanction ultimately depends upon the entire material, relevant fact, evidence placed before the competent authority, so that the competent authority has full knowledge of fact to make a decision either to grant the sanction or deny the same. Your Lordship, kindly peruse to section 67 of written submission at page number 20. Your Lordship, in the present case, they do not have any evidence, they do not have any facts, they do not have anything at the table. How can they provide valid sanction to prosecute the same, to prosecute the accused Samir and Monu under the stringent legislation of UAPA? As my co-counsel stated, that declaring someone terrorist as declaring someone as death, Your Lordship, clearly applies in this case, Your Lordship. They do not have relevant fact, they do not have anything against the accused, and even after that also, they frame the accused under the said section, which is very heinous in nature, which kept both all my client, that is Samir, Monu, Kalu, behind the bar for 6 years. They suppress the voice of minorities. They suppress the voice of dissent. Your Lordship, in the healthy society of democracy, this should never be happen, Your Lordship. With this, Your Lordship, with the permission, I would like to proceed to the prayer.
Yes, please.
Indeed, Your Lordship. Much obliged, Your Lordship. Your Lordship, wherefore, in the light of the facts stated, issue raised, argument advanced, and authority cited, it is most humbly prayed and implored before this honorable court that it may be graciously pleased to acquit the accused Samir Monu Kalu of all the charges under section 120B, 121, 123, 201, 489B, and 489C of IPC 1860, and charges under section 16, 17, 18, 20 of UAPA, and pass any other order, direction, or relief that it may deem fit in the best interest of justice, equity, and good conscience. For this act of kindness, the accused shall duty bound forever pray. And Your Lordship, it is an honor to argue in front of this court. Much obliged, Your Lordship.
Few very brief questions.
Indeed, Your Lordship.
Firstly, you referred about the Caesar witnesses.
Indeed, Your
You
Lordship.
said only on one independent witness, And if you want to make out a case based on that, then
s-
what could have prevented the prosecution from fetching another independent witness? Doesn't it say that the seizure took place then and there?
Your Lordship, I would like to answer this with the relevant circumstances. Your Lordship, the seizure took place at a crowded place of Delhi police at Old Delhi railway station. It's a crowded place. The place is a public place. The place where we see a lot of the person, and in between those, police did seizure. Your Lordship, it is any reasonable person can infer that police can very easily find any of the person to authenticate the same, or even police can request the person, and police must have to show that they have requested and the person willfully denied to be a part of this investigation. However, the police didn't show that also, Your Lordship, this creates doubt if we see not this act in isolation, but if we see the in all circumstances, including this act, we can definitely infer from these circumstances that there is something suspicious, there's something fishy in the investigation of the police, Your Lordship.
Another issue, short issue, is
Indeed, Your Lordship.
about the facts not mentioned in the FIR having
Indeed,
been
Your Lordship.
mentioned in the charge sheet, what you submitted.
Indeed,
Do
Your
you
Lordship.
expect all the facts mentioned in the charge sheet to be part of the FIR without any investigation?
No, Your Lordship. Indeed, no, Your Lordship. Your Lordship, FIR is just to start the investigation. Police received information about fake hidden currency that accused accept. However, they charge the accused under section 120B, 489B, and 489C. Your Lordship, this much is clear. However, how do they come to know at the time of filing of FIR that they are trying to wage war against the state? They charge under section 121. They charge under section 123. They charge under section 201. Your Lordship, not only that, they charge under section 16, 17, 18, 20 of UAPA. How do they come to know that that the accused will do such thing? Lordship, not only this, Your Lordship, they charge five accused. How do they come to know that these are the five accused with a proper name, Your Lordship? Your Lordship, this cannot be understood by any reasonable mean or by any mean that they are doing a non-prejudice investigation or they are doing an unbiased investigation, Your Lordship.
One last
Indeed,
thing.
Your Lordship.
You mentioned about FIR number without the registration of FIR.
Indeed, Your Lordship.
Can you please repeat it? And those who are for the prosecution may kindly take a note of it. You will have to respond to this.
Indeed, Your
Please
Lordship.
repeat this.
Indeed, Your Lordship. Your Lordship, for that, first I would like to peruse to paragraph number 17.8 of the charge sheet, page number 1717. Your Lordship, I'll be quoting those lines. After the seizure from crime scene, on return to police station, a case-wide FIR number 15/2015 was registered. Your Lordship, if we see the arrest memo and the seizure memo, Exhibit 3, page number 28, Your Lordship, they clearly stated that the FIR number is 15/2015. How could that be possible, Your Lordship? When they didn't register FIR at the time of seizure and arrest, how can they write FIR number 15/2015 at the time of seizure? Lordship, this create havoc in the havoc of investigation of police, Lordship.
Suppose, should I?
Indeed,
Suppose a accused has something which is not. Suppose he has something which is illegal. In this case, fake notes, and the police random search पे या secret information पे उसको apprehend करती है.
Indeed, Lordship.
तो immediately apprehend करेगी. सबसे पहले उसको उसकी तलाशी लेगी.
Indeed,
तो सबसे पहले उसकी रिकवरी हो जाएगी.
Indeed, Lordship.
उसी प्रोसेस में पुलिस का ऑफिसर अपनी तहरीर लिखेगा. You understand these words? In Delhi में
Lordship,
असल तहरीर, the first complaint which is sent to the police station for registration of FIR.
Your Lordship, the council is not aware of the word tehreer, so
This is Tahrir, Urdu word. It has been very widely used in North India.
Indeed, Lordship.
तो वो फर्स्ट कंप्लेंट होती है दैट इज कॉल्ड असल तहरीर, जिसके बेसिस पे एफआईआर दर्ज होती है. एफआईआर तो फॉर्मेट में आती है ना, दैट्स द फर्स्ट इंफॉर्मेशन रिपोर्ट. बट फर्स्ट इंफॉर्मेशन रिपोर्ट इफ गिवन बाय समबडी इन राइटिंग, दैट फर्स्ट राइटिंग बिकम्स द असल तहरीर, जैसा सामान.
Indeed, Your Lordship. Indeed, Your Lordship.
तो वो रिकवरी को इन्वेस्टिगेटिंग ऑफिसर हु वाज प्रेजेंट एट द पुलिस ऑफिसर हु वाज कॉम्पिटेंट टू इफेक्ट द रिकवरी, should he wait for that asal tahrir वहां पे एफआईआर दर्ज होके वापस आए, और he should immediately take the fake notes in possession by
Indeed,
making
indeed.
Caesar memo.
Your Lordship, I may be wrong, but Your Lordship, with your guidance, I try to answer it. Your Lordship, in this case, what the police should do? Police cannot left the accused to freely roam here and there, to free from any investigation. Your Lordship, police should recover the money. Police should seize the money, and police, in as we have read in our classes, that the concept of zero FIR is there. So, Your Lordship, in the present case also, the officer who is present there should do. Your Lordship, here we use the word zero पर कायमी करते हैं. So, Your Lordship, at that time police do something work on zero, that is write zero anything, and when they
Zero is something else. You
It's
search
something else.
हाँ, इसको सर्च करना कभी. But you all are doing very well. इसमें तो हम
Indeed.
कॉम्प्लीमेंट करेंगे. You all have done very well. उसको सर्च करना. वो जो
Much obliged.
बहुत अर्जेंसी के मैटर्स होते हैं जिसमें रिकवरी हो जाती है, पहले रिकवरी को इफेक्ट कर लेते हैं. एफआईआर रिकवरी भी एफआईआर का हिस्सा बन सकती है.
much
कह देते हैं कि हमें सीक्रेट इन्फॉर्मेशन मिली, हमने ए को एप्रीहेंड किया तो जब हमने उसका लिफाफा लिया, उसके हाथ में जो था लिफाफे में हमने सूंघा तो वो हमें चरस लगी, तो हमने उसको कस्टडी में ले लिया, वो ये सेंडिंग दिस. तो बाकी सारी कार्रवाई साइमल्टेनियसली बहुत तेजी से चलती हैं.
Indeed, Your Lordship. But Your Lordship, if
Tell me one thing more. Okay, that's topic
Indeed.
needs investigation on your part.
Indeed, Your Lordship.
You tell me one thing. Is there any law कि सीजर मीमो पे अगर पुलिस ऑफिसर्स ने साइन किए हैं as witnesses, वो inadmissible होगा, या उसकी वैल्यू कम होगी, या उसको सस्पिशन से देखा जाएगा?
No, Your Lordship.
What is your
There
argument, precise argument on this point?
Indeed, Your Lordship. In Your Lordship, there is no such law that when the seizure memo is been signed by any police officer, their admissibility or their credibility can be questioned. However, Your Lordship, in the present case, they have done.
Admissibility or credibility, which would be questioned?
Sorry,
Admissibility
Lordship.
or credibility?
No, nothing can be questioned, Your Lordship, because there are some circumstances
Your
where.
argument goes that way.
Sorry, Your Lordship.
Then your argument goes.
That way.
If you yourself are saying that nothing can be admissibility cannot be questioned, but yes,
Indeed.
credibility can be checked by
Indeed, Your Lordship.
kind of safeguards. The public witnesses were available there. But
Yes, yeah, that's what I'm trying to say, Your
High
Lordship.
courts and Supreme Courts throughout the country are repeatedly saying कि जनरल पब्लिक इन कामों में आती नहीं है सामने बहुत बार.
Indeed, Your Lordship. But Your Lordship, if that would have been seen, the police must have write something in the charge sheet that they try to ask a general public for any help, and they didn't provide it. That help, Your Lordship. But in the present case, Your Lordship, it is a crowded place. It's a public place. It's a place of people where people live, where people can found in abundance, Your Lordship. It's very hard to assume that none of the people come forward for the same, and police didn't try anything for that, Your Lordship.
Have you searched कि अगर some public witness को कहा जाए you be witness in this seizure memo or recovery memo, और वो मना करके चला जाए, what is the authority left with the police officer, what he can do with such kind of person who has refused or showed his inability to be a witness to such document?
And one connected issue, on the railway station, most of them are travelers जो आ रहे हैं जा रहे हैं.
Indeed, Your
Why
Lordship.
do you expect them to become a party to this investigation and to a criminal trial for which they'll have to come all the way from the native place to depose in support of the seizure?
Your Lordship, with the permission, I would like to answer the question of Your Lordship Manish Mohan.
Yes, please.
Your Lordship, in platform, we didn't find only visitors. There are local vendors. There are auto rickshaws walas there. The police can also ask to them, but police didn't do that. Your Lordship, the question of yours, that whether when the police asked for any help of independent witness and they humbly rejected. So, Your Lordship, in the case of Sadhu Singh versus State of Punjab, the Honorable High Court of Patna High Court stated that there is the public witness may not join the investigation, but attempt has to be made by the police officer present there to ask them for their help, because after all the police is doing their work, Your Lordship. It is there for their protection, and it will be better for them to help them, not to deny them, not to get away from them.
Sadhu Singh versus State of Punjab and
Indeed,
Patna High Court. Isn't there a contradiction?
Your Lordship, I may have, I may not know by the of which court, but it's the case of Sadhu Singh versus State of Punjab. And Your Lordship, if you allow me to cross-check it, I will do when our time for rebuttal, Your Lordship.
One last issue, that is a word of caution which my brother also pointed out.
Indeed, Your
Try to
Lordship.
search whether there can be named accused in zero FIR.
Your Lordship, I think you have confused with this concept of zero FIR or zero ki kaimi. Your Lordship, these are two different concepts, Your Lordship. And I will search upon it, Your Lordship.
Please work on that.
Well done. You all are doing very well.
Well done.
Much obliged, Your Lordship.
Rebuttal.
One small query from the prosecution side. How do you explain the gap in the prosecution story regarding Caesar, which the defense has adequately highlighted?
Much obliged, Your Lordship. It has been contended that in the memo, the information that has been provided in the charge sheet, the memo, the information which was provided by Guddu Singh was on 24th at 900 hours with respect to when the train would come in. The as has been mentioned by my learned friend, the police is for the protection of the people, and we didn't want to prosecute witnesses without any relevant evidence. So we waited for the apprehension to actually happen. The train, when it reached the station on 10:55, it has been noted that the arrest has been made on 10:20, and immediately after the same, the FIR has been written. So they, because it's such a crowded place, and the accused were trying to abscond, they were trying to hide in the general coach, honorable court. This goes on to show their sinister plans. Because of that, there was a considerable time which took to apprehend the same and then write the FIR. So there's not been a delay, but a due diligence on the part of the investigation agency.
How was the FIR number in the Caesar memo?
The Caesar memo has been made on 22nd of this thing, this 22nd of February, Honorable Court, I apologize. And the FIR's date has been provided as a precursor to the same.
Which came first, the FIR or the Caesar memo?
The FIR, the Caesar memo, Honorable Court.
So therefore, what came later could not have found mention in the document which came prior.
Much obliged, Honorable Court. The council would just take some time to answer that. And also, Honorable Court, in this particular instance, it would be pertinent to say that the accused are trying to take shelter of the trivialities in the a particular case in a desperate attempt to save themselves from the prosecution of their terrorist activities. This has been laid out in two particular cases, one by the Supreme Court in the state of MP versus Dayal Sahu, wherein such trivialities shouldn't mask the or shouldn't color the opinion of the or the culpability of the accused in the present matter, because there's such because the culpability has been laid out quite clearly in the present case. They're trying to reach for the trivialities.
Such a blatant defect in the Caesar, can you refer to it as a triviality?
Honorable Court, the 22nd is a mere typing error which has been made. So the FI, pleading the particular, I apologize for the confusion. The FIR had come first, and the date is a mere triviality because it was a printing mistake, and that has been done. That is why the FIR's mention has been done, because the Caesar memo was made after the FIR.
So if the FIR was prior, please narrate the events.
The information was received on 24th of February.
An apprehension takes place.
Yes.
Then the Caesar memo is not prepared there. Then things move back to the police station for registration of FIR,
Yes.
and then the seizure memo is prepared. So
Yes.
that means that the seizure didn't take place at the place where the accused were apprehended or where the seizure ought to have taken place.
The seizure has taken place at the at the instance of Farakka Express when they were apprehended in pursuance to Section 43B of the UAPA Act. Because once the fake currency and and the apprehensions of the problem and the questions of a point wherein they found 2,000 rupee denominations in the midst of a demonetization thing and a currency crunch which was prevalent in the country, that raised suspicions. So that thus invoking and the high quality fake currency codes, if the court would peruse that there have been mentions in the numbers which have been provided. A lot of those numbers have been procured, and because due diligence was performed, it was found that it was high quality fake currency notes, because high quality basically refers to the printing quality of the same. So in pursuance to the same, because we knew that a bigger ploy was in place at the particular instance, a seizure was done in lieu of Section 43B of the UAP Act, wherein it states we have to be forthright, the police officers have to be forthright in seizure, so that such malicious people can be caught and the chain of events can be stopped at the particular instance.
My brother said,
हाँ, ये मैं आपके स्टेट के स्पीकर नंबर 2 की तरफ से पूछता हूँ, जो सीजर हुआ, रिकवरी हुई, उसको लैब में भेजने में देरी का कारण क्या एक्सप्लेन किया गया? What was the reason to sending it at a delayed
There
stage?
wasn't really any delay in sending it. It can
No,
be.
this question was not from. You are not required to answer it. Speaker number 2 of your team.
Oh, apologies, Honorable Court.
Honorable Court, there was no delay in sending the seized currency to the notified authority. However, with respect to the preliminary report that the notified authority is supposed to report is supposed to give to the police, in that circumstances, in that case there has been a delay owing to the nature of the act that was committed. The seized currencies were in huge number, and that led to a bit of delay in the same. So this again furthers the contention of the prosecution that due diligence was followed, and in lieu of the same, there would have been a delay of a few days.
And your material reflects how much, कितने दिनों का delay था, number of days, delay of how many days?
Your Lordship, from my side.
You can also answer.
Your Lordship, that preliminary report has been given to the authorized officer on 16th April, and and police apprehended on 25th February. 30 days, sorry, 45 days, 48 days, Your Lordship.
It remained in Malkhana.
Your Lordship, it remained. It took 48 days to receive a lab report, preliminary lab report, Your Lordship. Not the final lab report, only preliminary lab report.
Goes on to show, as has been elucidated by my learned friend, that there wasn't any delay from the investigating authorities' side in sending the CFSL for examination, for the expert opinion of the CFSL. There was a delay in reception of the CFSL report because the CFSL authorities were undergoing due diligence. So we had submitted it as how we received the fake currency.
The defense was not correct on facts when they were saying that they were delaying sending the samples to the.
Your Honor, there is no mention of when the police actually sent the currency to the CFSL.
Report got delayed.
Yes,
so there is no mention that when the currency was sent, so it cannot be presumed.
You all did wonderful.
all did
The council seeks permission to rebut this statement.
Is that required? We have both of us have cross-questioned you on various aspects.
All right. Honorable Court, the one which there were some sections which you had elucidated that the prosecution should rebut them, particularly section 196.
Time की shortage है.
If the court would just would just give 1 minute extra,
हाँ, चलो.
that would also be enough. The section 196, clause 2, it as has been mentioned by my learned friend, that the due diligence was also not provided, and then they could not have apprehended them and all of that. The particular case is evicted from the ambit of section 196 of CRPC under the clause 2 of the same, because wherein it says that if there is a conspiracy which is in place, whose punishment is either life imprisonment of more than 2 years, which in the present case is it's imprisonment of or life imprisonment and or imprisonment for 10 years. So it again evicts the ambit of the same. Again, the accused have been relying of admissions and section 313, which was again relied upon my learned friend, that but the same would be used in inquiry and trial, and not that can the section cannot be used by the police. Furthermore, the details of the seizure has been provided in 17.4, wherein an independent witness, namely Ravi Kumar, has been mentioned. So the contention of the lack of independent witness is quite baseless. Furthermore, the secret cavity has been mentioned in 17.3 in the advent of the FIR again in the charge sheet. Furthermore, under Schedule 1 of the UAPA Lashkar-e-Taiba, which the particular accused were working in consonance with, the CFSL reports the expert opinion of the CERT, the location which was provided. All of these corroboratively tend to the culpability of the accused in the present case. And furthermore, Kalu Mama's the court, wherein they said that the court has not been given to. It has also been mentioned that in 17.30, again the sections of Rule 6.4 of the procurement of Caesar and Kalu Mama in the Kalu Mama's presence in a local court has also been fulfilled, which has been required and has was elucidated by my learned friend. Again, there was no delay in of 12 hours, as has already been answered by the council prior to this. Furthermore, the new district court, I would like to elucidate that there are two particular aspects, that they were belonging to new district, but they boarded the train from Malda, which proves that being the very physical being of themselves was present in Malda at that particular instance, and shows the physical presence in the conspiracy, not just the telephonic records as has been alleged by the defense, so as to get them out of the ambit of UAPA. Also, it's a very desperate plea from the accused to get them out, but again, they're only relying on trivialities and trying to get out of the case, but the case, as the council submits, it's pretty clear. Again, the expert cordial relation which was presented by the learned friend, it has been mentioned by Iqbal Singh and by defense witness C's own admission itself, because as has been elucidated by the learned court itself, that the contradictions and omissions can be brought out by section 161 of CRPC. A contradiction in the defense's statement can also be brought out, wherein it said that Sohail and Kalu Mama were working in consonance with consonance with each other, and they were in constant touch with each other, and there were no friction between the two, but they were working in very nice relations and were going on their terrorist activities, thereby threatening the sovereignty of India. These are the only.
Moreover, Your Lordship, with respect to the missing testimony of Iqbal Singh, it is cited that the prosecution is not bound to examine all the cited witnesses, and it can drop the witnesses to avoid the multiplicity and the plurality of the witnesses. This has been done by the prosecution just to save time of the court, so that repetitive dispositions are not witnessed by the honorable court. So this contention that there is a missing testimony
Apology,
of
Your
Iqbal
Lordship.
Singh is
Apology, Your Lordship, to intervene,
baseless.
but it has been provided in the rule that only one speaker can rebut, Your Lordship.
Yes, yes.
Your Lordship, I would seek 2 minutes of the court's time to rebut some points of the prosecution side.
Let them speak out first. Let them speak out.
My lord,
out, and then
their time is already up for rebuttal. They had taken 5 minutes.
Honorable court.
Your Honor, there is a crunch of time. I would take just 2 minutes of the court's time to sum up some of the arguments for the rebuttal. Kindly allow me. Uh, Your Lordship, it is a very blatant remark from the learned prosecutor that they are saying that we are relying on the trivialities of the matter, but it is the case when we are deciding the life of three accused who have been in the behind the bars for 6 years, and your conviction would decide the life of these accused for the further period, and it cannot be declared very blatantly by the prosecutor that only trivialities we are relying only on trivialities because these trivialities matter for deciding the investigation process. If it had been in a fair or reasonable manner, or it had not been. Furthermore, Your Honor, I have been very frustrated by the use of word admission by the prosecution, because there has been no admission, and which admission is entertainable before this court or not. There exist some sections in the Indian Evidence Act, section 2526 or 161 or 162 of CRPC, which cannot entertain such admission in front of this court. Furthermore, Your Honor, they are relying on the CDRS for showing the connection between the accused, but it is humbly contended that the call detail records are cherry picked on certain locations on certain times. I would request the prosecution to show the location of the call detail records of Samir and Monu when they boarded from the train in Malda. They are just stating that they boarded in the train from Malda, but there is no proof to certify the same. Furthermore, Your Honor, the prosecution is trying to justify the chain of actions, but we are not contending that the fake currency notes were found in possession of the prosecutors. We are still saying that they have been implanted by some foreign body. Also, it has also been mentioned that Your Honor, I would take 1 more minute of the court's time. The time for rebuttal was. I've just two, three points to make. Your Honor, the accused were not trying to wage any war. They were not in contact with any local militant
So
body
you
or
can
the
stop,
terrorist
you
groups.
can stop now because it will have a chain reaction if this session gets delayed.
Indeed, Your
In,
Lordship.
I will only say two things to end with. Firstly, what we are not so much interested in rebuttals on fact. What we are more interested to see is your repartee and your sense of presence in how to rebut it. You could have simply said that pointing out these trivialities in the prosecution case is the best weapon in the hands of defense.
Indeed, Your Honor.
Number one. Number two, you'll have to refer to the use and the purport of section 161 CRPC again, because this is one rare instance where I've seen the prosecution people referring to and relying upon 161 more than the accused defense team. Generally, it is the defense which refers to and relies upon 161 for the purpose of contradicting the prosecution witnesses. Here it is just the reverse. So anything that my brother wants to say? That's it.
Good. That's it.
You all did good job. So we don't want to comment upon the fate of the accused, but you all get acquitted from our court.
ये बहुत अच्छा किया. Wonderful. All did wonderful.
Much obliged, Your Honor.
So
So
God
with
bless
this,
you and best of luck.
with this, we end up the session.
Our
And
good
it,
wishes,
Thank you, Your Lordship.
good wishes from
it was a pleasure organizing this session, and it was really insightful. So thank you so much, both the judges, and all the best to the participants. Thank you so much. I request the judges to send us the score sheet via email or on WhatsApp. The judges have to sign the score sheet and scan and send it to us.
That's right.
By what time?
Sir, we want the score sheets at the earliest because we have to decide who is going in the next round.
Sure. 15 to 20 minutes will be fine.
Yes, sure, sir. Thank you so much. Thank you, everyone.
Thank you.
Thank you, sir. Good afternoon, sir.
Thank you, sir.
Thank you.